G'day folks, welcome back. It's me again, Maro, lucky you, and today we're going to do the case of Kalkat and easy recruitment. This is one of those cases where you get dismissed and you're sort of working for the recruitment company, you're sort of working for the actual employer, and things haven't been done spectacularly well, and the authority is left to answer the question, who's in trouble and how much trouble are they actually in? Now, in this particular instance, Mr. Kalkat is given some work. He carries on this for a while, clearly on the basis that he is effectively a casual employee of the recruitment company. Along comes Lynn Fox, offers the man a job or offers a job to or an opportunity to the organisation. And there's a little bit of a misunderstanding here because Mr. Kalkat's under the impression he's got a 3-month trial and then he's an employee. And the recruitment company is under the impression, as the employment agreement appears to suggest, that effectively he remains on the terms and casual conditioning that he has always been on. Life passes as it does with a degree of optimism and joy for all the parties until, of course, the optimism and the joy dies. At that point, there is a problem in that allegedly Mr. Kalkat sends an aggressive, if not threatening, message and appears to leave work one day an hour early. There is a note sent through to the recruitment employer saying, hey, look, not happy with this, not happy with this, not happy with this, let's just call the whole thing off, which the recruitment company decides to do. As you can imagine, the employee, Mr. Kalkat, says, hey, hang on a minute, I've got a completely different idea about what's going on here. Let's have a conversation. It obviously and ultimately cannot be resolved up until it gets into the authority. And the authority says, look, I get that there's some ambiguity here. I understand the situation, but an employee is an employee, a claim's a claim, and an investigation should always be an investigation. And there simply just wasn't one here. You can't rush to judge. You absolutely need to look into the circumstances. You can't just say that a placement came to an end. There's clearly some form of punitive response at play here, and that requires an actual investigation and an actual consideration of what has gone on, which has not happened. So as you can imagine, the court, or the authority rather, finds on behalf of the employee, and the employer or employers, as the case may be, are left to rue the fact that if you do wish ultimately to bring such an engagement to an end for effectively some kind of performance and misconduct basis, you need to make that clear and go through some form of process that meets that standard rather than not. Ladies and gentlemen, boys and girls, as always, my pleasure and my privilege. Have a good time, and I'll catch you fellas sometime soon. Cheers.